Good morning, everyone, to Foundations 101 podcast, third episode. Joining me as the first time is Kath Zagatti. Kath Zagatti, good morning.
Good morning. Thank you for having me.
A pleasure. So we had quite a lot of response following our two podcasts, and they were all about real estate. Is Foundation a good tool for real estate? And maybe for some context there, ever since the Dubai real estate market opened more than a decade ago to foreign ownership, investors have been looking for the most appropriate, robust tool to hold, consolidate, and protect their real estate. And I'm delighted to announce the search is over because Foundation are the tool, as we will demonstrate today. So what I want to do today is go through this mailbag of questions with you, Kath, so that we can shine a little bit of light on something that at heart is reasonably easy. Are we ready?
Yes, sure.
All right, let's do it. So let's start with a little bit of context and background. How has the DLD's practice evolved over the past decade, and where are we today?
So the right to ownership of Dubai properties was given to foreigners in 2006 in certain areas of the Emirate, which was called designated areas. Since then, of course, the Land Department has been reviewing and updating this list. So from 2006 until 2012, the Land Department was assessing the registration of properties with foreigners on a case-by-case basis. For instance, it was very common to see at that time properties here being registered directly with offshore entities located outside the UAE, like BVI companies. However, in 2012, the DLD changed this approach and decided that JAFSA IBCs was the only type of offshore entities being able to hold properties in Dubai. Not only that, the Land Department also restricted the corporate structure holding the property up to 2 layers only. So again, a common example of corporate structure at that time was individuals holding BVI and then holding JAFSA IBC, which you would then hold the property directly. So as you could see, it was a big challenge for investors to invest in real estate here in Dubai, as they did not have the right tool to do such investments.
So you mentioned that there was a little bit of Far West and then some regulation, perhaps even over-regulation. So what's new and where are we today?
Yes, sure. Since 2018, the Land Department became flexible in terms of property ownership. So the Land Department has executed a series of MOUs, which means Memorandum of Understandings with few free zones in the UAE, to it the DIFC, ADGM, RAC, ICC, and RACES. So by virtue of these MOUs, now entities registered with these free zones can hold directly properties in Dubai. So the game changer here is that the investors can now invest in Dubai real estate using sophisticated structures incorporated in a common law regulatory framework, for instance, companies, partnerships, funds, and as we are discussing here, foundations.
So foundation and real estate compatible?
Yes, definitely compatible. So for the past year, we've been registering Dubai properties directly and indirectly with foundations. The only thing I must note here is that currently the Dubai Land Department is only accepting DIFC foundations as owner of properties.
So beware, always ask for the latest practice from your advisors or us at MHQ, because it has changed in the past, but it seems to be now clearly set with the Land Department understanding the tool and accepting DIFC foundation for direct real estate holding. So with this in mind and these 2 years of practice restructuring Dubai real estate, what is the impact you see in practice using foundations?
Yeah, the use of foundations for investments in Dubai tackles 2 important issues. First is local probate, and second is the complexity and bureaucracy related to the use of multiple structures. So for those who don't know, the local probate is a process that takes place right after someone's death. So in case the deceased was holding assets, not necessarily real estate, but any type of assets, the local probate will have to be put in place after this individual passes away. And as you may know, this is a lengthy procedure and it has to involve the Dubai courts. And on top of that, the distribution of the assets might not be in line with what with the deceased wishes. So this was the first issue. The second issue was related to the bureaucracy involved when the property is registered with many with a corporate structure having many shareholders. So whenever the beneficial owner wishes to transfer shares in any of the entities involved in the structure, the land department will require full set of corporate documents of every single entity involved in this structure. So, and if the company is located outside the UAE, then the legalization of the documents will have to be prepared. And again, this is extremely costly and time consuming. And on top of that, all these documents would then have to be translated into Arabic as part of the land department's requirement. So the use of foundation to hold properties would eliminate these two issues that I just talked about. First, because by having the property registered with the foundation, the property is no longer part of the founder's personal wealth. So even if the founder passes away, the property will be intact. Nothing will happen with the property, and there will be no need for local probate. And since the foundation is a domestic structure, there will be no need for legalized documents, and most of the free zones already issue corporate documents in both languages, Arabic and English. So there will be only a few documents to still be translated in Arabic.
So clearly a simplification, because now there is this tool available here, a compatibility of the tools, and decrease of costs, really, as a result of the implementation of the AFC Foundation to be used in connection with Dubai real estate. We have this comparison chart which shows individual ownership versus foundation, and clearly this is a no contest in that a foundation can consolidate the assets, protect them, legacy plan, carve them out from probate. So the advantages is huge. If you were to own one or several properties in your name, you could, yes, cover them with a will. If you're non-Muslim, it works, but that would not prevent probate, dispute, etc., or attacks from creditors. So a foundation helps you tackle all this. This, I think, is clear to our viewers, but what I like to stress is this. A lot of people have been led to believe that having a JAFSA offshore, a JAFSA and a BVI on top was like the golden grail of structuring real estate. It isn't. It serves some purpose, consolidation being one of them, but it does not address legacy planning. It just pushes the issue at the top of JAFSA or at the top of the EI. It does not address a risk. Someone can sue you, your wife or husband can divorce you. All these risks are real life risks, which exist if you hold a name or through a company, which does not exist if you have a foundation and it's properly administrated. So I think it was important that we put it out there for the people. I want to talk to you, Kath, about the process, because now clearly we are encouraging people to consider restructuring, optimizing their structure, both for robustness and cost arbitrage. If we are encouraging people to do so, they need to understand what is the procedure and how much will this cost me in terms of transfer fees. So let's talk about the procedure. How does one register Dubai real estate under a foundation?
Yeah, so there's actually no difference between registering a property with a foundation and a company. It's exactly the same procedure. So basically, the land department will request full set of corporate documents, as I just said, of the foundation, and the NOC of the register where the foundation is registered. Aside from this, also an NOC from the developer of the property. Yes. So after having these three set of documents, then after also paying the applicable fees, the land department would then issue the title deed under the name of the foundation.
So nothing spectacular compared to a company. You talked about
Not at all.
the fees. So let's assume I have my Mr. X here and he wants to transfer something onto a foundation of which he's himself the beneficiary. You see the structure popping up. What would be the transfer fee here? Would it be the standard 4%?
No, it would be only gifting fees, which is 0.125% because the transfer is being made between the same beneficial owners.
Very interesting. So you can qualify to this gifting rate, irrespective of it being to you, to say your wife, or to you, to a structure of which you and your immediate families are beneficiaries. A quick question on this. What if I decide at some stage to change the beneficiaries of that foundation? Would it still be 0.1 to 5%, or would it be 4% then?
It will depend on who the new beneficiaries will be. So naturally, if the founder is the father and then the father passes away and then the new beneficiaries will be wife and children, then the land department will apply only the gifting fees because it's direct family members.
So you would have a notification mandatory to the DAFC, which in turn would notify DLD, and you would pay the 0.1 to 5%, which incidentally is what would happen if there was a probate. You would need to notify and pay that gifting fee anyway. So nothing different here. Now, I like this example, very visual, because hopefully it will help clarify when 0.1 to 5 and when 4% apply. So we have Mr. X, he sets up a foundation. Now he has been for some time holding this property, not only for him, but also maybe for some other members of his family, say 2 brothers. You see them identified here as beneficiaries. They are coming to the party and say, hey, we want to be registered there. So if we do that, which is good for asset protection, the asset is segregated and it can survive Mr. X passing if he was to. What would be the fee applied to not Mr. X, where we have seen that it was 0.1 to 5, but to these 2, his brothers? Would it be 0.1 to 5 or 4?
It will be 4% because the gifting fees is not applicable to brothers or sisters.
Okay, so gifting fee limited to parents, spouses, and kids. So one vertical and not outside of it. Fine, understood. Very clear. Now, I have here the same example. Mr. X sets up a foundation and he makes his son the beneficiary. This, I venture to guess, would be 0.1 to 5%, correct?
Correct. Yes, gifting fees.
And what about Mr. X is something that we see a lot, setting up a foundation, structuring an asset under it and making his wife the first beneficiary. This is good for family security. Mr. X maybe is an entrepreneur, so he wants to protect that asset in case one of his personal guarantees bounces, etc. Now, what happens if his wife passes away and his son that has been a pre-designated beneficiary substitute him? What percentage would apply then?
0.125% gifting fees, because it's from mother to son.
So that's the example you gave before. Very clear. So the takeaway here is that if you are considering restructuring, if you keep it in the family, it is a very palatable transfer fee of 0.1 to 5, as opposed to the 4% we got used to in the open market. Now, what I'm interested to know is, we talked about change of beneficiaries. What I'm interested to know is, how does it work for restricted properties? Because we have freehold, these are clear, but what about land that is restricted to GCC national or UAE nationals in Abu Dhabi? Would the same transfer fee apply? I would venture to guess yes, but is there something that one needs to pay extra attention? First, does it work for GCC and UAE national?
Yes, definitely, it works.
It works. So is there something special that I need to pay attention? Maybe identify beneficiaries, maybe some special clauses in the bylaws?
Yes, so as you said, for non-freehold areas, only GCC nationals can be the founder and the beneficiary. So in this case, what we usually do to our clients is that the initial beneficiary is a GCC national, and then in the bylaws and letter of wishes, we set different classes of beneficiaries, where class B, C, and D would then be the family, the UBO of the structure.
I see. And you would also identify in the bylaws that this is strictly set for GCC or UE national and is always to be held on their behalf, so that the
Yes.
land department is then comfortable with you being
course.
compliant with the system and not
Yes.
circumventing it. Okay, clear. So we tackled a whole area around real estate. I appreciate there must be many more potential queries. So if you have some, if you're listening, feel free, drop us a note. We'll be happy to tackle that, whether about mortgage, financing, joint ventures, etc. We're very, very happy to tackle these and illustrate them as part of the new session, which incidentally, next week, we'll be talking about the same example that you have in front of you, but from another angle. This time it will be compatibility of foundations for Muslims and how this works with the law of the land here in the UAE. Small hint, it does work. So hopefully see you next week and we'll talk to you how it works for Muslim. Kath, Zagatti, thank you very much.
Thank you very much.